Good morning. Oops, let me press that. So good morning, everyone. My name is Lauren Misek Vargas, and I'm with Education Rights Council. Elizabeth Einen-Kokerda, as Deborah mentioned, will be on in a moment. She is also the co-founder of ERC. She is actually currently in a juvenile court hearing. So today, what we're going to be focused on is cultural competency, students with disabilities, and how that functions within the juvenile system. And let's see. Okay, so my name is Lauren Misek Vargas. As I mentioned, I'm the executive director. Myself and Elizabeth run a nonprofit organization called Education Rights Council. We specifically focus on removing legal barriers so that all children can stay in school and thrive by creating systemic change. So by doing that, we try to build an alliance of educational advocates. And so we do trainings just like this for the community to make sure that everybody just has this much knowledge, if not some more comprehensive knowledge in regards to education rights of students. So today, just briefly, what we're going to be going over is a history of equity for students with disabilities. We're going to be discussing invisible disabilities, or what we have termed invisible disabilities, quote unquote, and discrimination. And then also, how are we helping juveniles obtain rehabilitation through educational supports? As Deborah mentioned, if you have questions and you want them to be answered, please put them into the chat. Myself and Elizabeth will be monitoring those, but we will, because we're kind of tight for time, we'll probably be keeping those till the end. All right, so let's kind of just begin with a historical background of IDEA, Section 504, and ADA, and the ethics of access. So, many people probably know about Brown v. Board. That is a pretty famous court case, even if you're not an attorney. And so Brown v. Board was pretty much the seminal case that overturned Plessy v. Ferguson and essentially stated that children that were different race, or Black children, would not have to have separate but equal facilities. That in theory, or in law, was actually inherently unequal. And therefore, with this case, it took away segregation. Everybody kind of probably has some basic understanding of that. But what you may not know is that because of this seminal case, and part of the argument of the not proponents of Brown v. Board, but the people who were arguing against it, said, well, judge, in the Supreme Court, if you allow African-American children to come in, or Black children to come into our schools, then who else can come in? Native Americans, Asian Americans? Can those children with disabilities come into our school? Because as many of you may remember or know historically, is that many children with disabilities were either kept at home, not given a public education at this time, or they were kept in facilities or institutions. Here in Nebraska, you might know Beatrice State Home. That's where a lot of kids were at this time. And so the court said, yeah, but we still think that that's inherently unequal. And so this opened up the opportunity for advocates or litigators to consider, what does this look like for children with disabilities? And so two really fundamental cases came out of this construct of due process, and that is Parks v. Commonwealth in 1972 and Mills v. Board of Education in 1972 as well. And so specifically, these addressed education for children with disabilities and looked at how can children with disabilities, do they have equal access to a public education? And the court determined, yes, they do. Under the Due Process Clause of the 14th Amendment, or the Equal Rights Clause, to give parents specific rights, they struck down local laws that excluded children with disabilities from schools and established that children with disabilities actually have the right to a public education. Now, one thing that you may not know is that education rights is actually one of the most litigated areas in the nation, not necessarily in Nebraska, but across the nation. And so we're going to talk about what is litigated and why, because once children with disabilities were able to go into the public education sphere, it was, well, what type of education? Can they be segregated from their general education peers? What is adequate? What are they entitled to? to. All these questions came up and all of these things started to be litigated. So the very first law that was passed in regards to individuals with disabilities was Section 504 of the Rehabilitation Act. Before Section 504, there was responsibility for consequences of disability rested on the shoulders of the person with the disability. So what that meant was that as a society, prior to Section 504, we said, you have a disability, too bad, so sad. It's your job to figure out how you can access a courthouse, for instance. If you have to go to the courtroom on the 6th floor, sorry, try to figure that out for yourself. Or if you need accommodations in your workplace, try to figure that out for yourself. But why Section 504 is so fundamental is that it really changed this construct of the social model of what a disability is, which is not to focus on the impairment of the individual, but to look at the individual as a person not as disabled, but an individual human being that has a disability, right? Or has ADHD or has the lack of ability to walk. So we need to, as a society, better accommodate these individuals or individuals with disabilities to ensure that they can be meaningful participants in our society. And this is where this social mental shift came. And Section 504 was really a huge moment for the disability advocate community. So it took about 4 years of regulations to be implemented. And essentially how this happened is disability advocates started to look at, well, how were civil rights obtained? So they started to apply the exact same constructs. They started to do sit-ins at lunch counters. They started to be refused to be removed from buses. And one of the most, I would say, emotional things that happened was there were individuals who literally left their wheelchairs, their ability to walk, or their assistance, and crawled up. I think it was called the crawl in. They crawled up the steps of the Capitol. And it was so emotional and so impactful that the federal government applied and created Section 504. Now, Section 504 applies only to federally funded buildings, but the regulations laid the groundwork for what we know as the Americans with Disabilities Act, which is ADA, and it would extend all those protections to private institutions and workplaces that were enacted about 13 years later. So ADA, and this is one of those things that you may know, is the Americans with Disabilities Act, was introduced into law in 1988 or signed into law in 1990. This is what you may see why there's ramps in federal buildings or in public buildings, why on the sidewalks you might have like kind of those bumpy, I'm not exactly sure of what the technical term is. I apologize. Those indicators of when you're getting to the street for individuals who may be blind. So all of these things were created under ADA. And it's kind of alarming, right, that that happened in only 1990. And so there was a concerted effort by the Supreme Court.
Lauren, I accidentally muted you. Can you unmute yourself? Sorry.
That was a big problem. I apologize. I'll state that again. So ADA really started to look at how is public transportation, access to buildings, safe sidewalks, interpreters available for court, for instance, a myriad of different things that were created under ADA. And this was a huge action, but did it specifically apply to children? And it really stems out 504, Section 504 and Section ADA, excuse me, the Americans with Disabilities Act really stem from the civil rights movement. Oops. So, and it really kind of focuses on this concept of what is the least restrictive environment. And I believe Elizabeth is here. Is that right, Elizabeth?
I am right here, and my apologies to all. I had a quick court hearing, but I am on and excited to join you. Thank you.
Okay, perfect. So the least restrictive environment is a concept, and now it's applicable in law, that essentially an individual, in particular, a child with a disability, should be maintained in what is the least restrictive environment, that they should be given access to, as much as possible, to general education peers. What is quote unquote normalized education, or what is the ability to function in society as a quote unquote normalized peer? Elizabeth, anything else you want to kind of speak to that about?
Well, I don't want to be repetitive. I think that what we learn from the history is that, because have you gone kind of over the background of ADA and 504, and yeah, so the cultural rationale behind all of that, what goes back to the whole Brown v. Board concept, which is separate isn't equal. And so what you see, and we're going to be talking about the cultural competency of understanding what the rights and obligations are for students with disabilities, always carries with it this construct of least restrictive environment that is based in these constitutional notions. So have you talked about IDEA and where it's come from yet?
Not yet. That comes next. Yep.
So
I think that's a good place to say.
Let me give this just a preview, which is you have all these, you have individual action, you have people marching, you have court decisions, you have legislation that comes out of those court decisions, and all of that functions in this notion of civil rights and the construct of civil rights. When you get to IDEA that Lauren just put up, and I'm probably going to go over, this is no longer a civil rights bill, but it still carries with it all of that intentional inclusion, all of that cultural sensitivity to ensuring that the person comes first, that these are not disabled people, that these are people who have disabilities, that we as a society make sure we make room for instead of excluding. Lauren?
Yes, sorry, I think my internet paused for a moment. I think let's kind of go into IDEA. And I mentioned previously that this is one of the most litigated areas. I think it's really important to understand, just like anything out of the civil rights movement, is that all these changes and laws came out of litigation. And so inherently, there are aspects that have require advocacy, right? Require advocacy and an understanding of the law. So with IDEA, it was formerly known as the Education for All Handicapped Children Act. Obviously, that is not terminology that we use currently, but it was changed to IDEA, or Individuals with Disabilities Act, in 1990. So it is crazy to think that it really wasn't very long ago that these rights did not fully exist for children. And that's part of the reason why I think getting them to be fully realized by the entire community is so imperative, and why ERC exists. So in 1970, US schools only educated about 1 in 5 children with disabilities. And I mentioned it was part of the reasons because many of them weren't entitled to go to public education, and they also were not, and some were institutionalized. And many states even had laws that excluded students, especially if you had an intellectual disability, if you're emotionally disturbed or have mental illness. And so the US now in 1990 has now progressed to be including 1.8 million children with disabilities from public schools, to providing more than 7.5 million children with disabilities with special education and related services designed to meet their needs only in this 2018-2019 school year. Now, obviously, that probably has even expanded since the pandemic, given that so many children have mental health needs that are needing to be addressed. But that is just one aspect of how quickly this law has transformed the ability for children with disabilities to access their education. So I think this is a really imperative slide and kind of talks about those constructs, and it's easier to visualize. So IDEA, as Elizabeth mentioned, is an education-based law that, yes, stems from all this litigation that happened through the civil rights movement, but it's an education-based law. It's a federal law that then is applied through by the states, and Elizabeth will kind of talk about that funding stream here in a moment. And it is a law that, and FAPE we're going to discuss, is called Free Appropriate Public Education, but that applies from birth to the age 21 years old. Okay, so you have this right from birth to the age 21 years old. Now, there's 13 categories of verification. We're going to discuss what that means in a moment. And you are entitled to an evaluation and to request an evaluation if you believe that a child has a disability or has something that is impeding their ability to learn. And that evaluation by law needs to be completed within within 60 days. Now, if a child is verified, they then are able to access an IEP or an individualized education plan and receive services, accommodations, and direct instruction. Now, with Section 504 and ADA, the reason that they are different, and Elizabeth, please feel free to jump in, is that these are civil rights laws, but all apply in the context of the public education sphere and for children. Elizabeth, anything I missed?
No, I think what you just last said is really important. So today, what we find is everybody focuses on IDEA, and we're going to learn a lot about what those rights are and how to assist children in accessing those rights so that they can be active participants in our democracy and, learn to get the challenging opportunities to which they have a right. But at the same time that we focus on IDEA, Section 504, which came first, continues to apply. And the difference between 504 and IDEA is this, in very basic terms, the idea of accommodations versus instruction. So if you have a student and you're worried about a student and you're worried that they need some kind of assistance, they may need the kinds of assistance that are simply called accommodations. Accommodations might be sitting in front of the class, wearing headphones, taking a break, getting longer time to take your exam or finish your homework, or shortened assignments, or pretty much anything that the team feels would be appropriate to accommodate the student. And that accommodation language comes from the whole civil rights notion that society will provide accommodations to embrace all people, regardless of their walk of life. And it continues to apply even when IDEA applies. So the school district's obligation is to meet both of those. And in fact, to also meet the third. There is FAPE, free appropriate public education, in IDEA and 504, and they're not exactly identical. So there's a rather large responsibility and set of rights that apply to students. And we don't want to overlook one for the other. Often, unfortunately, they get swallowed up in IDEA solely because there have been court decisions that say, if you are meeting your child's obligation under IDEA, then ergo, you're meeting 504. But the contrary is not true. So if IDEA doesn't apply, 504 still does. And sometimes they apply in parallel. In other words, you may have 504 prohibits discrimination on the basis of disability. That's why we call it a civil rights law. And so you can have discrimination that stands, I'll call it separate and apart from implementing IDEA. The reason this is really important is because when you are advocating for a child to ensure that they have appropriate services, you can have 504 services in place even while you're determining whether IDEA applies or not. They kind of can go hand in hand. I don't want to get any more detailed into that.
Okay. So let's kind of talk about what are invisible disabilities and discrimination. So what we want to do here is really just kind of frame your thinking in why is this important? So we talked about the history, but also why is this important here in Nebraska from a national perspective and for individuals who are working in Douglas County specifically, hopefully with individuals who are in the juvenile justice system. So many disabilities are invisible or misunderstood as behaviors. So disability has a particular definition, and it's up here, and I'll read it aloud, but a disability is a person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such impairment. And so I think the biggest piece here that is important to understand under IDEA and when we're talking about education rights is that it's impeding their ability to learn or to access the instruction that they need to be able to be on level or on par with their general education peers. Yes, Elizabeth?
Right. I mean, I just want to make it really clear. A major life activity is learning.
Yes.
So if something's standing in the way of learning, you have an impairment that's standing in the way of a major life activity. And a lot of people think about disabilities just like those photos when we showed you the civil rights movement for individuals with disabilities. We sometimes think, oh, it's the child who has Down syndrome. I can see that. It's the the child in a wheelchair. I can see that. It's but what we also know is that things like what's down here: anxiety, depression, PTSD, ODD, ADHD, autism. None of those have like a little label on your forehead that says, this is a challenge of mine. They're invisible, yet they all fall within potentially the definition of a person with a disability if those things are impeding their access to education. So that's why it's really critical. I have seen far too many court reports where there is a diagnosis of any one of these invisible disabilities. And then the individual who's making the report to the court is asked, should the child, is the child eligible for special education? Should the child be evaluated for special education? And people mark no. And I don't understand it until I realize that there is continually this lack of recognition that we need to understand that mental health and any impairment on our mental health that impacts our ability to go to school. I can't go to school and I stop going. I'm not attending. Well, something's standing between me and a major life activity. What is it? It may not be a disability, but it very well may. The first question I have when I see a kid that has excessive absenteeism is, have we looked at that child to see if we know what's causing that? I mean, it may be that they moved. Okay, fine. It may be that their mother is in prison and they're highly anxious, or they're homeless, or there's something standing in the way. So we can't just say excessive absenteeism is not a potential sign of an invisible barrier that we should be addressing through the rights that children already have under 504 and IDEA.
One just quick thing I want to mention here. Here it says TBI, but that's a traumatic brain injury. And I see Peggy Reiser from Brain Injury Alliance on this conversation. Obviously, she has way more information about this. But one thing that we see oftentimes when we're working with children, especially who have neglect cases, and I see a lot of people here either with medical experience or at Boys Town or some other group homes. I just want you to be aware that when you're assessing and looking at that paperwork or your records, especially the court reports, there are so many times that children within the system that have been removed from their homes who have experienced physical abuse likely have a traumatic brain injury that literally changes how their brain, the neurocognition of their brain. And so that is something to really be aware of, and that we have seen so often in our cases is that it's completely neglected, not just necessarily by the school. They might not even have that information, but I'm saying by the entirety of the system, medical providers, even the courts, to when we're looking at those records to make sure that that is brought to the forefront, especially if a child's coming in under a delinquency, but has been in a neglect case in the past. Elizabeth?
Yeah, I think that what happens here is, again, the more visible thing in these instances is potential behavior that arises because the neurological framework of the child is different now than somebody else's because their brain has been permanently rewired. And so what people do is they focus on the external, and it's really important to look at the internal. I don't know if there are educators on this call, but I think that they would let you know that what you would do to intervene and support a child who has a TBI, as in it's a neurological difference as opposed to just a behavior, I won't say just, but a behavior disorder, they'd be very, very different. Just like if you have Tourette syndrome, you may very well be able to feel an episode coming on, know that it's going to be disruptive, not want to disrupt, and still not be able to stop that from happening. You don't have control over it. That's very different than a child who needs to learn to recognize that when they start to become agitated, there's a better way to handle it than just having, evidencing it in the classroom by shouting out or getting angry. So the instructional methodology and the supports will be significantly different. And what we see sometimes, as Lauren was saying, is that when we haven't gone through and looked at the records, what we think we're doing for the child is not necessarily appropriate for the child.
Mm-hmm. Okay. So one of the things that we want to talk about is that children with disabilities are disproportionately pushed into the system. And by the system, I mean the juvenile justice system or the criminal justice system. So students with disabilities comprise less than 12% of high school students nationwide. This statistic is from a national study, but they represent 75% of students who are restrained, 58% of students who are secluded, and more than 13% of those students are subject to out of school suspension, meaning that they aren't accessing their education. Students with disabilities who are eligible for IDEA, that means they're verified and have an IEP, represent 25% of students who are arrested and referred to law enforcement, even though they only represent 12% of the overall student population. So there is a terminology that is utilized across the nation called school to prison pipeline. And today we're not here to discuss whether that's true or not, but this is one of the reasons, and this information is one of the reasons why advocates believe that there is this inclination to push kids into the criminal justice system or to discipline them for their disability instead of providing particular services. So here is a video that we're going to watch about a child in Florida. And tell me if it does not work.
So you know where you're going?
Can they hear it?
Okay.
Can
It looks
you hear
good.
it? Okay, go ahead.
You're trying. I don't think so either. And you can justify follow them. You understand this is very serious, okay? And I hate that you put me in this position that I have to do this. Okay? All right? The thing about it is you made a mistake. Now it's time to learn from it and grow from it, right? Not repeat the same mistake again.
Okay, so obviously that's really emotionally triggering, right? To see a child, especially as young as 8 years old, to be arrested. And thankfully in Nebraska, children can't be referred to the criminal justice system at such a young age. But this is really to just demonstrate that in this instance, a substitute teacher who didn't understand the child's disability, who probably wasn't informed about the IEP, made a judgment call that in fact was not in accordance with what the law and the rights of the child was. And therefore it led to the child being arrested and probably further traumatized. Elizabeth, do you want to say anything about that before I switch?
Yeah, I think the one thing that's really important to understand, not too long ago, I was on an IEP call and we were trying to make sure, because in the past, the student's IEP had not been well communicated to staff. And the law actually requires that the needs of a student be communicated to anyone that's working with the student. And that includes substitute teachers. They need to have that information up front. And the staff member said, well, we can't share that information. And they said because of FERPA, which is a Rights to Privacy Act that's completely not applicable in terms of sharing with instructors the need of the child. So what we find is these things happen, and a lot of times it's due to significant lack of understanding by everybody involved, including the school staff. So we end up pushing children out and into the system and taking punitive action lots of times because of a lack of understanding. And it's one of the reasons that we as ERC try to give these types of presentations, is to expand the understanding of everybody in terms of rights and obligations so that this kind of thing doesn't happen. I will tell you, we might not be putting handcuffs on children in terms of, we still label children in this state, 7-year-olds, as people who assault people, even though the language of assault doesn't apply until you're 18. The school penalties label children this way, which I find is very problematic when we're dealing with babies. And I will tell you that this is not, I'll call it, these statistics apply equally from pre-K to high school. So it's not when we say X amount of kids are, a disproportionate amount of kids with disabilities, it's all at the high school level. It starts at pre-kindergarten, and that disparity exists, sometimes even a worse disparity for our younger children than our older children. And the younger children, I mean PK to second grade. We, our children in PK to second grade are getting very much disproportionately disciplined on the basis of disability, and they're much less likely to have gone through the evaluation process.
Okay, so did I skip it? No. Okay, most juveniles who are detained are children with disabilities, and this is also from a national perspective. The number of kids with disabilities in juvenile corrections is 3 to 5 times greater than the number of children with disabilities in public schools. Some studies have shown that up to 85% of youth in juvenile detention facilities have special education qualifying disabilities, meaning that they could receive services. Yet only 37% of youth in detention facilities who needed special education services received that actual support. Because there's such a disproportionate percentage of detained kids with disabilities, and there's such a disproportionate amount of children of color that are in detention facilities, this gravely impacts children of color with disabilities. There is lots and lots of studies and lots of people on a national level who are really thinking about how to look
Judge.
into this process.
I was making sure I sent it to you.
Hey, Dammy. Okay, keep going, Lauren.
Oh, okay. Did Dammy allow us to hear his court hearing?
Yes, he did, just for
okay. Okay.
I was gonna say that might have been Judge Brown too.
Sorry, Dammy. And that it really, if we had provided those services within the detention facility alone, it actually could have changed that trajectory in terms of recidivism. So not having a child come back, that transition between the detention facility and into the school would have been more streamlined, and setting that child up with those services would have stopped them from coming back and potentially committing more crimes.
Yeah, and we need to say, and we'll talk a lot about it, but wherever you are, you still retain your rights under IDEA and 504 to a free, appropriate public education. It doesn't go away just because you've been detained.
So what does this actually look like in Nebraska? We've been talking a lot about national studies, but what does this actually look like here? So in Nebraska, there are 54,000 children with verified disabilities, and 26,000 of those children live in poverty. Education, as you may have guessed, as we're kind of talking about this, is extraordinarily confusing. Education law is very nuanced, and many people do not understand how to even navigate it. That includes lawyers, judges, families, even sometimes school staff don't have a full concept of what these rights look like. In fact, I was a special education teacher for several years, and part of the reason I went to law school is because I felt handcuffed by not having enough information, not enough knowledge to advocate for the students that were in my own classroom. Because the access to justice gap is so big. So for instance, in an IEP meeting, unlike if you have a criminal charge, you're entitled to a public defender, you aren't entitled to have an advocate. You're not entitled to have an attorney that sits with you and helps parents understand how to navigate the law. And so if you are struggling to get the proper services, instruction, you may have to seek outside counsel to kind of help and sit down with you and help you assist in navigating this system. Now, unfortunately, if there's 26,000 children here in Nebraska who live in poverty, they may not be able to access, their family might not be able to pay $3,000 to $5,000 for an attorney to come and sit down next to them. And that's part of the reason that Education Rights Council exists. One of our programs is direct representation, and we do provide direct representation to individuals who are 250% of poverty and below. We also believe as a nonprofit organization that by training attorneys, advocates, families, and any individuals just like yourselves, medical providers, in education rights and responsibilities, we all can understand or at least be able to ask the right questions to hold everyone accountable across the system, right? Not just schools, but also families, also the court system, also detention facilities, group homes. We want to talk about accountability because what is right for kids, and that's what we all want, is to make sure that they have access to these education rights. And we need to improve existing special education delivery and enforcement of systems. So that's also part of this accountability factor. Do you want to say anything on this, Elizabeth, before I jump to the next slide?
No, I was just scanning the chats.
Oh, okay.
And there was just one question that probably we could answer right now that I don't think got answered, which is, there are separate legislative mandates for students potentially suffering from brain injury, but are there specific legislation for diagnosis beyond IDEA 504, et cetera? I'm not sure I quite understand the question. In other words, what the legislation requires in terms of what we're talking about is that every single child in the state be identified by the school district pursuant to, or school districts, pursuant to child find. Child find is an obligation that arises under IDEA. There may be other legislation relating to, I know that there was some legislation introduced saying we should also try to do early diagnosis for autism. That stalled in the legislature, but whether it's autism or anything else, there is legislation right now that actually requires every school district in the state to identify children through evaluation, if the parents permit it, of every possible type of disability.
Okay, so just like from a national perspective, there also is disparate impact here in Nebraska. In the 10 most populous cities in Nebraska, Black and Hispanic students comprise 24.4% of students. However, they represent 35% of referrals to law enforcement. They experience 48.5% of out-of-school suspensions, 52.2% of expulsions, and 67.1% of all transfers to an alternative school. Because children with disabilities are overrepresented in every category of discipline, this overrepresentation leads to what we talked about from a national perspective, that children of color with disabilities are funneled into the juvenile justice system, which obviously impacts not only their academic performance and their ability to achieve and be a productive society member, right, going to college or obtaining things beyond graduation, but also to their social and emotional growth as well. So it's very likely that the troubled kids, or when I was a teacher, we used to call it the kids we love the most, have disabilities and are getting the needed education and are not getting the needed education services that they are entitled to. So many children might have disabilities that are easy to identify. We've talked a lot about this today, but there's so many disabilities that are verifiable under law that are very hard to recognize. So what are those red flags? And we're going to talk a lot about this, that when you are an advocate, if you're working with children in any field, that you need to be thinking, hey, maybe this kid needs to have an evaluation and see if they need a verification. Some of those things would be consistently poor grades. So a child who is failing every single class for years and years and years, okay, that child might need to be evaluated. Delays in meeting developmental milestones. Let's say that a child is unable to walk, or doesn't have the capacity to speak, or is nonverbal by the time they get to kindergarten, or is still wetting themselves, or is inappropriate in terms of social interactions. All of those things may be the time to have a child to be evaluated. Now, here's one that I think these two pieces are really interesting. I think a lot of people, especially with high schoolers, think that lack of interest in school or not going to school or truancy is on the kids sometimes. Like, they don't want to go to school, they hate school, all that kind of stuff. However, oftentimes when we start looking at records, we see a trajectory that it starts really, really early on, that this child is not probably getting the services, or they've been really successful at one point. Let's say they were a straight A student, and all of a sudden they fall into a bout of depression, and now they're failing all their classes and wanting to skip school. So these pieces, especially frequent reports of misbehavior, if you're seeing a child with more than 25 to 30 misbehavior reports in a school year, that definitely alerts us that a child should be evaluated. Yes, Elizabeth?
So I know you said years and years and years, because often that's what we see, but it doesn't have to be years and years and years.
Yeah.
And that, in fact, that's what gravely concerns me. Too many of our children it's exactly what Lauren said, which is, I received a court appointment a couple days ago, and reviewing the students' records in 2010. Reminder, it's 2022. In 2010, this child was having behaviors and had a learning disability, wasn't able to read. The services never really changed. The reading level never really changed. What did change is the behavior. The behavior became worse and worse and worse. The child was obviously exhibiting all sorts of signs of oppositional defiant disorder, intentionally misbehaving to escape any activity that had to do with reading. When we look at it, it screams, oh my goodness, this child should have been evaluated several years ago, should have been determined as to whether this child needed additional supports and services. And so 10 years later, where is that child? In the system. That child didn't start in the system, but that child ended up in the system in part because that child's inability to read was never met.
I think another really key factor, and Elizabeth kind of mentioned this before, is what we see is that a child comes into the juvenile court system, they receive a co-occurring evaluation or a psychological evaluation or psychiatric evaluation. A doctor diagnoses them with anxiety, ODD, PTSD, any of these kind of invisible disabilities. And then we kind of throw our hands up and we say, okay, either they can get medication, they need therapy, and that's what we think our job is, and that's where it ends, right, from a juvenile court perspective. And the answer is actually no. Those are also triggers that maybe we should be asking ourselves if these things are limiting or impeding the child's ability to learn, and therefore should they receive an evaluation, and should we make that request? Because oftentimes it doesn't go to that next step. All right, everybody. We are going to take a 5-minute break, and we're going to kind of jump back and get into the real nuances of the law. If you have questions about what we discussed right now, please put those into the chat and we'll address them first thing when we get back.
I handed him your phone number and I said, call him back and set it up because I won't be here.
I don't know who that was, but
mute.
Okay.
Okay. So we'll take a little break, right?
We'll see everybody back here in 5 minutes.
Perfect. Okay, everyone, we're going to start coming back together here.
Should we give everybody like 2 seconds to hear our teacher voice? So we say,
Totally. Yep.
Us will resume, ding, 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 like that. Not really type teacher voice, is it?
I don't know.
Way back in the day, teacher voice.
Mine was always quiet coyote.
Quiet
Close
coyote.
your mouth and your ears open for listening.
Wow, that's interesting.
Mouth closed,
Quiet
ears
coyote.
open. No? Any other teachers heard that before? Maybe I'm
All right.
dating
Well,
myself.
yeah. I think, Lauren, I'm going to start so that you can have a drink of water.
Sounds great.
What we want to start with now is truly the process of helping juveniles obtain rehabilitation through educational supports. So this part of the cultural competency is going to talk about both equity and then how to get equity. Lauren, you want to flip the slide? I don't think I can.
Yep, you can't. Okay.
All right. So as Lauren alluded to, we really need people to have at least a general knowledge of IDEA. Earlier on, I said, this is kind of the primary law in education itself that ensures that children get instruction. So they get services that are direct, like resource, related, like OT/PT, they get assistive technology, and they get accommodations. So understanding that under IDEA, all of that may be necessary to get what we call a free, appropriate public education. Boy, I've got to work on that. Free, appropriate public education in the least restrictive environment to every child. Now you're saying, I can't sit back and read all those federal laws, but Nebraska has done you a favor. And so when you are like excited to relax at home in the evening, you can just pull up Rule 51 and you can read all about what the rights are. One is the Nebraska Department of Education set of regs for implementing IDEA. And this is how you can find it if you ever want to learn more about it for those that are lawyers on this call that are practicing. The one thing I would say about FAPE and least restrictive environment is that this whole notion is to ensure that we have equity. Can you flip the slide? FAPE is about equity. I think we see this described multiple different ways, but we have had a conversation about this locally and nationally, and equality and equity aren't the same. Both seek fairness, but equality presumes that we all start at the same point and then are treated exactly the same. And we know that we don't all start at the same point. And so because not all people begin from the same place, they need different opportunities to achieve education. And we see this across the board. So I think what I was going to say on the prior slide that I forgot is Rule 51 pretty much mirrors federal law. And that's because where does all this come from? Where does this notion of equity come from? It started, again, through federal regulation and funding. Now, I think most people know this, but in case you don't, there is no constitutional right to an education in the United States Constitution. Where does it come from? It comes from states who have adopted education. In order to become a state, you had to prove that you would educate your people so that we could have an active democracy. And as far as special education, what happens is the federal government takes a block of money, hands it to the state, says, state, you get this money if you make sure that you comply with these rules. And the state says, okay, we'll take all these rules, we'll put them into this nice, pretty book, we'll call it Rule 51, and we'll have all the school districts comply with it. And so school districts get a block of funding that is very different than, for those of you who speak Nebraska School Financial Ease, TIOSA, which is the student funding formula. Special education funding comes in a completely different way. Either way, what it's about is making sure that we can provide these different resources to different people so that, as you can see on the little thing, everybody gets to see the game because they get different resources to get there. You want to flip? Okay. Equity in case law. Prior to a very important case called Andrew F. v. Douglas County School District. Now, you're like, where's that? It's in Colorado, even though it's Douglas County. So Andrew F. was a decision in 2017 that took on a notion that went back to the 80s in a case called Rowley. And in the Rowley case, basically it was, well, okay, we've got these laws, we got this money. What does it mean? What are we going to do for children? And different circuit courts took different approaches. So some circuits said, basically, you do something to make a difference, you're good to go. Others said, well, that doesn't make sense. It has to be meaningful. I mean, what's the point of making a difference that doesn't make a difference? This went all the way up to the Supreme Court for a child who had autism. They felt very strongly that the school district was not meeting the child's needs. They pulled the child out, provided private schooling for the child, and took it all the way to the Supreme Court with regard to what does FAPE mean? What is appropriate, for goodness sakes? How much benefit has to be provided? And effectively, what the Supreme Court held is that there has to be meaningful, change and challenging that provides every child the opportunity to meet challenging objectives. So it set a higher standard. In some states, everybody went, yeah, we're already doing it. However, we in Nebraska are part of the 8th Circuit, and we were not doing that. So it definitely had an impact on the requirements that we need to meet for children in our circuit. You want to flip? So what exactly did Andrew F. say? Basically, they said, we're going to define FAPE for you folks. FAPE is an IEP that's reasonably calculated to enable a child to make progress appropriate in light of the child's circumstance. Now, what does that mean? It means that the program has to be appropriately ambitious. Now, let's be very careful about the term program. Program means what you're teaching the child. Okay, it's not like you went and bought a program in a box and said, oh, is the program from Sylvan Learning appropriate? That's not what we mean by program. What we mean is everything we put together, the instructional curriculum for this child is appropriately ambitious in light of the child's circumstances. Now, they always say, just as advancement from grade to grade is appropriately ambitious, the goals can differ, but every child has to have that chance to be challenged. So one of the things when we start talking about how do we, a lot of you on this call may, in one or more walks of life, sat in on an IEP. The challenge is, if you do not understand all the parts of the IEP and how to ensure that what that IEP is doing is actually putting in place goals that meet the child's needs, because an IEP is effectively a contract between the school and the child. And once that contract is in place, similar to contract law, if those things don't happen, it's a breach of contract. So if you're going to write a contract, you should make it very clear, very specific, very much in light of what each individual child needs. Once you've created that, you have FAPE. If there are problems with it, you may not have FAPE, in which case we may have a situation where the child is not getting what they have a right to. You want to flip? I already went over this, so you can go ahead and flip. So what is in this big old magic box called IDEA? Well, the answer is a whole ton of stuff because it's pages and pages and pages, but we're going to try and simplify just like the key content areas, because one of the things we think is really important is we can sit here and talk to you for 1 hour, 2 hours, 8 hours, 16 hours, or give you a 6-month course. And you're still probably not going to have all the nuances. But the most important thing is to think in your head, oh, wait a minute, wait. I think that this might be something a child needs. To recognize that we need to ask, is this something? And to recognize how to get it. So what is an IDEA? We talked a little bit earlier about this obligation for child find. The money comes in from the feds. It goes to the state. The state says, here, school districts, you need to go identify any child, and it's not any child in your school building. It's not any child that could attend or will likely attend your school building. It's in your demographic area. So school districts reach out to hospitals. They work through their ESUs. They work with early childhood care providers, and they try to educate families because families can reach out in case the school didn't find them. But it is the obligation to reach out and say, from the time a child is born until the child is 21, May we evaluate your child to determine if we can provide services? That is an obligation called child find. If there is child find, you go to that next turquoise box. What is in it? Well, an evaluation is called an MDT. There's all this magic language. MDT stands for multidisciplinary team, and it has become synonymous with the evaluation itself. So it's the team, and people call it an MDT. What is really an evaluation? To determine whether a child has one of those 13 verification categories that Lauren alluded to earlier when she was comparing those 3 columns of IDEA versus 504 versus ADA. If there is an analysis and there is no verification and the family disagrees with that, the family has the right to ask for an independent education evaluation. Unless the school district decides to go to hearing over it, the school district has an obligation to pay for this IEE. You ask the school district to reevaluate where you think it's not appropriate. If they don't, you have the right to an IEE. Know that that exists. If after these 2 things, we do have a verification, you get an IEP, an individual education plan. We're going to talk a lot about what's in it. Part of what can be in it is what's called a BIP, a behavior intervention plan. There's not a BIP in every IDEA plan, IEP, but for children who have behaviors, we want to understand what's going on with that behavior and create what's called a replacement behavior. We'll talk a lot about that. It's not making the disability disappear. It's a whole different animal. But in order to figure out what is underlying that behavior so we can find a good replacement one, we engage in something called an FBA, which is a functional behavior analysis. So we do a behavior analysis, and then we try to put in place a plan that meets the child and the school's needs so the kid can stay in school despite a disability that may include behaviors. It also includes rights for children who have been disciplined. If a child has a disability that violates the code of conduct, and engages in activity that violates the code of conduct, when that activity causes a change of placement, i.e. removes them from the school for any period of time, up to, the maximum is 10 days. Hopefully a school district will be looking even earlier than that. They have a right to have a look-see and say, hey, was this behavior actually a manifestation of my disability? In which case we don't discipline disabilities. We try to create a replacement behavior. We also have things like transportation, shortened days, extended school year, which is not the same as summer school. We have a whole thing called transition in there that's really important in the juvenile structure to collaborate between what the school is doing for transition for kids between ages. Well, you start looking at age 14, but the idea is if I have needs that have not been met, maybe I've got my academics, but I still have social, emotional, and functional academic needs. I need to have those met and can have those met by the school district all the way to 21. So for those of you that are working in the juvenile system, why is this really important? It's that bridge that we've been looking for because kids come out of the system at 19 and what's there for them? Sometimes not much. We can use these 2 things together to bridge that gap and give the child more opportunities to learn. There's also something called recovery services and/or compensatory ed. That's when that contract that said you get X, you didn't get X, you have a right to get it made up for. That's compensatory ed and/or the school districts in COVID, because in many ways there was nothing they could do about the fact that they couldn't meet it. Their obligations still didn't end to meet it. So they have talked about recovery services here in Nebraska and across the country. And finally, what else is in IDEA? If all this goes to pot and it doesn't work, there's an entire due process system for dispute resolution that is very legalistic, in part because, as Lauren said, when this first arose, it came out of litigation. When something comes out of litigation, the statutes tend to mirror that adverse situation in the remedies. Next.
Just one quick thing here. We mentioned that IDEA applies, or FAPE applies to birth to 21. So when you have a child who's not, let's say, in the school system, right, but you're doctor, your pediatrician says, you know what, I think that this child maybe isn't speaking, like is nonverbal, needs to be evaluated. All this still applies in terms of child find. However, if they are under the age of 3, and it's kind of delineated here at the bottom, they don't receive an IEP, they receive an IFSP, which is an individualized kind of, it's a plan that functions in a similar way, but really is based off of early intervention.
Yeah, and it deals with families' needs as well as kids' needs. So between the zero and a family services plan is going to help the family understand how to help their child grow and develop prior to getting them in what we would call school age, which is 3 and above. So how is this supposed to work? Now, supposed to doesn't mean it always does, but it's sort of what I described, which is there's child find, there's an MDT. If there's verification, we create an IEP. If there's not, we create a 504. We put a whole bunch in that we're going to talk about into that IEP that are important. The strengths of the child, what the parents' concerns are, present levels. We're going to talk a lot about that. It's a baseline. You cannot put a plan in place to make progress if you don't know where you're starting from. It seems like a pretty easy concept, but a lot of people don't understand that you can't have a goal that says, Elizabeth is going to improve her math until she can do it 80% of the time. What if I'm already doing it 80% of the time? Okay, you need to have baselines. You need to talk about goals, services, all those other things, and you do it in the least restrictive environment. Then there are progress monitoring that happens. This is really important. People sort of forget about it. You get your IEP, great, well, we're good to go. How do you know if it's working? How do you know if your contract is worth the paper it's printed on? You have to see how's the progress going for the kid. If the goals that everybody agreed on are good goals and the kid isn't making progress, do we just sit there? No, we should be paying attention to it and maybe reconvening to see if we need to change that. All right, we have the BIP, we have FBAs. Every year, a school district is required to review the IEP and create new goals. And every 3 years, the school district is required to reevaluate to determine whether the child is still eligible for service. And we already talked about transition. I'm trying to zip along because I know we have some limited time and this is some heavy lifting we're doing. All right, we've talked about child find ongoing, but you need to know that child find applies. I'm focusing kind of in the third bullet down. All children, including those who are homeless, who are wards of the state, who are attending private schools, regardless of how severe or not severe the disability is, and who need special ed, are to be identified, located, and evaluated. It sounds like a giant, what do you call it, obligation, but it is there and we need to be aware of it. Okay, finally, child find applies to all children suspected of having disabilities, including those who have complex medical needs who reside in nursing homes. So we are going to educate children everywhere. Next. These are the 13, I'll call it magic categories. Unfortunately, every state in the United States, except for Iowa, is basically required to label what area a child is verified for. Verification is different than a diagnosis. Verification means I see things that meet definitions that are laid out by the state that are interfering in education. So I can be verified in the area of autism without having a diagnosis. Alternatively, I could have a diagnosis of autism, but it's not impacting my education. So therefore, I would not necessarily be verified under IDEA for specific services if I'm not having an impact on my education, notwithstanding a diagnosis. The one thing I want everybody to look at, and we've talked about before, the second bullet down, emotional disturbance. Those are a lot of our invisible disabilities. Specific learning disabilities. A lot of people think all of these are specific learning disabilities. Nope, nope, nope. It's a term of art. Specific learning disability means something like dyslexia, dysgraphia, dyscalculia. In other words, a reading disability. So if you do an assessment and I am doing great, I am an average intellectual. I am doing fine in math, but my reading scores are way below what's expected. I likely have a specific learning disability in reading, and I should have services specifically for that area. Lauren talked a lot about TBI and how it shouldn't be overlooked, but in any event, to be verified, the school district has eligibility guidelines that are long, that the Department of Ed puts out, and they try to see if what their evals say fits any of those definitions. Here's an example. By the way, the guideline for emotional disturbances is probably like 8 pages long. We just took a cut and paste. But here's what the school will do. They will say, is there an inability to learn that can't be explained by intellectual, sensory, or health factors? In other words, it's not that I have Down syndrome that's causing me there's something else that I don't know what it is. Or an inability to build or maintain satisfactory interpersonal relationships. I, unlike my general ed peers, overreact and act out in ways that were very unexpected based on certain situations. Inappropriate types of feelings, pervasive mood of unhappiness or depression. I'm not going to read all of this, but you can sort of see how it's a somewhat complex analysis to determine whether a child meets a particular verification. The reason you want to know about these, back up just one thing. If you are supporting a child and you're going through an MDT and you have looked at, say, a co-occurring evaluation that was in the courts, and you're seeing some of these things, you're going to want to read these definitions yourself so that you understand whether you, as a member of the team, want to say, I think this sounds like X. What do you think? The school will raise it, but you also want to be fluent in it. Okay, thanks, Lauren.
Elizabeth, I think there's actually a couple questions that I just want to address here. The first is, who does the evaluations in the school? We've talked a lot about evaluations. Is it a psychiatrist outside the school? Like, what does that look like? If you can just kind of explain.
So generally speaking, an evaluation that is for an IEP or, that idea to see if it fits under IDEA is done by school employees. There will be usually, depending on what the areas of concern are, you can have a school psych, you will have classroom teachers involved. You may have OT involved. You may have PT involved. You may have a nurse involved if there are specific health issues. So there's going to be, the evaluation covers fine motor skills, gross motor skills, academic skills, social emotional skills, intellectual abilities, all of those areas. And depending on what area of concern you have, those are going to be the people that are involved in that team.
And the other question comes from Chris Stewart, and this question is really specifically about, I had said that you may need to be provided with an evaluation, right? You kind of talked about this, that just because you have a diagnosis doesn't mean that you have to receive that evaluation, vice versa, right? You might not have a diagnosis, you might get an evaluation. But I think the key, so well, sorry,
I want to clarify that. If I have a child with a diagnosis, I am going to ask for an evaluation because I don't know if that diagnosis is interfering in my access to education. If I have a diagnosis and I don't ask for an evaluation, I may be doing that child a severe disservice because I might not see it. I'll tell you who's going to see it. The educators are going to see it. Now, just because I have that diagnosis and I have the evaluation doesn't mean the evaluation is going to show that my diagnosis is interfering in my access to education. But if I have a diagnosis, the school district should be made aware of it. They should immediately determine whether a 504 plan is appropriate, which is accommodations regardless of a verification. Because if I have a diagnosis, 504 applies, period, I'm in, over and out. In addition, it may be appropriate to have other services. And if we have any reason to believe that that diagnosis may be interfering in the access to education in one or more areas, an evaluation should be done.
And Chris, to kind of more of your question about how does this affect disenfranchised populations, potentially, like individuals like who fear the system or who can't trust the system and so forth. I mean, that's part of this. What we're talking about today is what the legal obligations are, not necessarily how they always are practiced or implemented. And so I think the answer to your question is that's why ERC exists a lot of times, is to help advocate. And there's many other organizations who do this too in Nebraska, like PTI, disability rights and so forth, to help families access those rights if they are wanting that to be done.
And I'm going to answer the one last part, I think, of Chris's question, which is how difficult is it to get a child tested? It shouldn't be difficult at all. There should be no barriers. Let me explain the two sides of this coin. One side of the coin is the school district has child find obligations. The school district is permitted to engage in a multi-tiered system to respond, to determine themselves if they can get over this hump without verifying a child. We don't want to unnecessarily or inappropriately verify a child. So there can be a multi-tiered response that the school district puts in place that includes SATs, et cetera, et cetera. That being said, if a parent or someone with educational authority says, I want you to evaluate my child, there's no ifs, ands, or buts. The school district has an obligation to do that and to do it within 45 school days or 60 calendar days, whichever is shorter, the end. So if you are somebody that is worried and has been asking for an evaluation and has not been able to get one, you have the law on your side.
Another quick question as we're talking about evaluation, and I think you briefly discussed this as an IEE, but can a student be evaluated outside of the school if they aren't attending school regularly? I think in terms of truancy, one of the things, and I will say that there's so many districts who have been so supportive in handling this for kids who are truant, is trying to think outside the box. A child doesn't necessarily need to be evaluated within the school. I literally have had individuals, or kids that we represent in juvenile court be evaluated at probation office because they have truancy issues. They have maybe disabilities that are impeding their ability to actually be evaluated in the school system. And school districts have really bent over backwards in a lot of cases to help provide that. But there is an option also, and I'll let Elizabeth talk about this in terms of an IEE.
Right. So yeah, I guess it's two different questions. There's three ways to be evaluated. On your own, you try it out, you get some evaluations, you bring them back and ask the school district to consider them. That's not really an IEE. Second is the IEE, which there are individuals across the state that provide basically the same exact type of comprehensive evaluation in a coordinated fashion that are identified by NDE. NDE has a list of them, and you may pick amongst that list. About the only thing that stands in the way of picking somebody is, you don't get to go to Florida. Okay, so the school district can say, yeah, I'm going to pay for this, but I can put a geographic limit. So pick anybody in the 200-mile radius or a 150-mile radius. The exception to that is if I have a very unique need. Say I'm a child with, I don't know how many people I'm thinking of. Okay, one child that I work with has something called Prader-Willi syndrome. It's an unusual syndrome that has multiple comorbidities. There's not necessarily an expert here. So perhaps for certain evaluations, depending on what they are, you might have to go out of that 150-mile radius, or maybe there's an expert here in Omaha, but if I live in Scotts Bluff or if I live in Kearney, I might have to go outside that school's radius to get that eval. I got off track. Is it what I forget, Lauren?
No, I think that's good. I think essentially all you need to know is that a family, if they are not satisfied with the evaluation, can request an independent education evaluation or an IEE, which I did put that. I realized we were speaking in acronyms and legalese, and so I did put what that acronym means. But I want to keep moving forward because there's lots to cover.
Okay. What is an IEP? Only a good IEP equals faith. So first of all, understand who's going to be there. This is the hardest part. I think somebody in the chat mentioned, what about families that are already disenfranchised? This is why having an understanding of being a good advocate is important, because when you walk in the room, there's going to be 8 of somebody else and 1 of you. And it's a language that you aren't speaking. And so it's very hard for you to keep track and understand and be able to question appropriately because there's a lot of people there. There are mandatory attendees and there are non-mandatory attendees. If a mandatory attendee needs to leave, the parent has a right to pause that IEP and reconvene when that attendee can come back. Statements of present levels are part of the IEP. A statement of goals are part of the IEP. How we're going to measure progress is part of the IEP. All of these services are part. Accommodations are part. Where we're going to participate. How often am I going to be with all of my gen ed peers? If I'm not going to be with my gen ed peers, where will I be? And how often will I not be with my gen ed peers? Time, place, and duration of services also is Where will that be? Will it be in another building if I'm not with my gen ed peers? Will it be 20 minutes? Will it be 20 minutes once a day, once a week, once a month? We've talked about transition, transfer of rights at age of majority. That's another complicated issue, because if you do not have a guardian and you're 18 and you have a disability, the rights to make decisions about your education can move with you. This is very important for those of you who are working in juvenile court, because sometimes children with disabilities do not necessarily have the capacity to make the decisions about what they need in terms of education when they're 18. And finally, we talked about what is in a behavioral intervention plan, the behaviors that are addressed, discipline principles, and restraints inclusion. That's really fast. And now we're going to go to some of them that are most important. Statement of present levels. This is the worst acronym in education. PLAF. Try to say it, or even don't. Okay, so we call them baselines because it's easier to say. These present levels describe how your child's unique needs result from the disability and how the child's disability affects the child's involvement and progress. And it includes a description of where they are right now, and these levels and functional performance should be included in each area. So if your child, we forgot to say this. Let's say I have ADHD combined and I'm a pretty bouncy kid and I need some breaks, and I get verified under one of those categories of verification. I can also have a right to services in other areas, even if it's not a verification. So if I also have a reading disability, I need reading goals, even though my verification is based on my ADHD. Okay, let's go. Let's look at what these have to be. Everybody talks about SMART goals. This is something I think I've heard so much in corporatese and legalese, and I'm tired of it. But here, it really makes sense. Every single time you're looking at a goal for a child and saying, is this an appropriate goal? You need to say, is it specific? So if it's, I'm going to make progress, Elizabeth will make progress. That's not specific. Is it measurable? Elizabeth will make 80% progress. If we don't know where I'm starting, that's not measurable. Attainable. Elizabeth will be fluent in French in 1 year. Probably not attainable. You don't want it. You want challenging goals, but not goals that are ridiculous. Realistic and relevant. If I am a 17-year-old and I still can't make change, I don't know that we want to be working on
trigonometry.
Pardon?
Trigonometry.
Right. Or I don't know that I want to be working on coins at this point. I want to be finding what is the functional skill I need to do so I can go to a score, so I can make change. You know, I forget math in my head. Show me the calculator. Forget reading Lord of the Flies. How about you teach me how to read a resume and write the resume? So we're on track for what my needs are given my individual circumstances. And timely means we can say when this is going to happen. Over the course of 1 year, given individual instruction and academic supports, Elizabeth will move from 65% recognition of keywords on the 200 most top identifiable words to 80% of those words, as evidenced by teacher observation and assessment in 4 out of 5 opportunities. I mean, I just made that up. I don't think it was bad. If there are educators, I hope you guys aren't going, no! Anyway, but that I'm trying to show specific, measurable, attainable, realistic, and timely. Go.
Oops. Sorry, I was frozen for a moment.
All right. After you've figured out what those goals are, you're going to figure out who's going to provide the services and where it's going to happen. While we want least restrictive environment, we want the least restrictive environment that works for the kid. If the kid is really sensorially impacted, the least restrictive environment for that child may not be the general ed classroom, but we don't automatically assume it's not. So when we say whether the child is going to participate in the general classroom, this goes all the way back to that whole notion of inclusivity. So it's never appropriate to go from gen ed to I'm not even in the regular school. I think the next one is our chart, is it? Yes, great. So this is the general placement for least restrictive. When we're trying to figure out where a child will be, what we start with is the general education classroom. If that's not working, we talk about it with accommodations. We're still in the gen ed classroom. We're pushing in accommodations and modifications to the program. Then we are in the general ed classroom, but we might be in the back getting very specific instruction, but we're still participating in the lesson. We might be having it presented to us differently, individually, still with our gen ed peers. Finally, we might be in the general education part-time, but we'll have some pull-out services. I'll take you out 1 to 3 hours a day. That might be level 1 services. Then we might find out that's not working. The better place is I will be part-time in the classroom, part-time not. A good example of this might be I do not do well in academics with my gen ed peers, but that doesn't mean I can't do specials. I can do music, I can do art, I can do lunch, I can do PE. I see too many situations where we have children that have high needs, but they're oftentimes the ability, they've been put into the next level, which is a self-contained classroom. They're in that self-contained classroom, but they are not getting the opportunity to integrate with their peers at all. They're not even getting an opportunity to go down the hall. We all know as parents and as teachers that what is most important to all children, disabled children, children with disabilities or children without disabilities, what do they care most about? It's not mom, it's not dad, it's not teacher, it's peers. They want to do what their peers are doing. And that peer influence is so important. We found this in study after study with regard to integration and learning, integration on the basis of race, on the basis of poverty, and on the basis of disability. So making sure you're in the least restrictive environment is so important, not just because the law says so, but because it's so meaningful for children. Finally, you may,
whoops, sorry.
Sorry. You may end up having to have the child in a school that is not run by the school district. This is when the child has needs that are well beyond anything the school district has the capacity to provide. The school district pays for it. When the school district pays for it, that does not stop the school district's obligation to make sure FAPE is there. It's just being allegedly provided by an outside provider. Then we get all the way to residential treatment in a hospital and or homebound. So those would be most restrictive. And I think it's really important when we're talking about restrictive environment, not to jump over those categories if we haven't tried them. Okay, transition services. I think we sort of talked about this. Perhaps the most important thing is transition services is not, Johnny took a survey and he wants to be a cook when he grows up. NDE has more recently really made it clear that transition services are to be robust.
What is NDE, Elizabeth?
Pardon?
What is NDE?
The Nebraska Department of Education has made it more clear recently that we want to start earlier in determining what we want a child to think about when they grow up so that we can create actual goals and instruction for those goals that may stop at 18 if the child is ready to graduate or may go on into the transition program and carry all the way through 21. So this should be robust. It's not just Johnny wants to be a cook. Okay. We've talked about behavioral intervention plans. As I said, they aren't required except in one specific case. And that's when a child has been disciplined and the discipline has removed them from, it constitutes a change of placement, which is 10 days or more out of school, and they do not have to be consecutive. Okay, so what's the word, Lauren? Begins with C, it's not consecutive. Cumulative, thank you. Cumulative 10 days. Then the IDEA explicitly mandates that there be a development of a BIP if the child has been subject to discipline and either the IEP wasn't followed or the activity the child engaged in was a manifestation of their disability. And manifestation means it's something that we all know I do. So it's important to read your MDT and your IEP to say, what does Johnny generally do? And I'm going to give you an example of this. Like, all right, we had one not too long ago where we know that Johnny is triggered when anybody comes up behind him. And his first reaction is to go like this. Okay, get off of me. All right. So Johnny does this. He hits the kid behind him with his elbow. Did he hit the kid? Yes. Would that potentially be a violation of the code of conduct? Yes. Was it directly tied to his sensory? And we've seen that these are his behaviors when he is sensorily agitated? Yes. Therefore, it's a manifestation of his disability. Okay.
Elizabeth, one question I had here, because this comes up often, is if you have a child who is truant all the time, like having difficulty getting into the building, right? Like maybe gets on the bus, but like won't get on to go into the building, runs away, whatever. Would that be something that should be addressed in the BIP, or should it be addressed in the goals, or can it be addressed by the IEP at all?
Yes, it can be addressed by the IEP. Yes, it should be part of the goals, because the BIP goals should be part of the IEP goals. There should be a behavior goal in the IEP itself. So IEP goals are not just academic, they include social, emotional, self-advocacy, and behavior. If you have a child that has difficulty coming into the classroom or getting into school, you can also seek accommodations. You may seek that child, I mean, if they're really anxious, but once they get in the classroom, they're pretty good, you might want to have an escort, meet that child and take that child to the first class. Or maybe that child, it's too much because the class is big, they can do the work, but they need to start out in a smaller environment. Or alternatively, they can go to the classroom, get the assignment, but then they need space to focus on the assignment, so they may move somewhere else. So you need to look behind. Why is my kid getting off the bus and going directly to the bathroom? Or why is my kid, everybody thinks they went to the building, but they're out behind the back of the building? I mean, when they're not coming to school, we need to figure out what is that and what can we do to facilitate making sure that we are addressing what's behind that to get the kid back in the swing of things. Did that answer?
Yes, thank you.
Okay. So what behavior is typically in a BIP? It typically addresses things like anger management, impulse control, antisocial relationships, those kinds of things, okay? But dangerous behavior and non-dangerous violations aren't the only thing that triggers the BIP. I think this is what you were talking about, Lauren. What is it that interferes with teaching, all right? If there is a behavior that interferes with that, a BIP can be appropriate. Excessive absences can be addressed in a BIP. So we need to think of this as somewhat larger than just, I'm so mad I'm throwing things. This is really, 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 really important. We think about behaviors and we think about, okay, Elizabeth's throwing things. What's my goal? Elizabeth won't throw things. Well, okay, good goal. However, I need to be taught how to not throw things. And I also need to be able to get rid of that stress that's causing me to throw things. I am not saying it's okay to pick up stuff and hurl it at other kids when I'm upset. That is not what I'm saying we have to permit happen. Not at all. But what I am saying is you need to understand why I'm throwing things. Then once we figure that out, we need to figure out what alleviates that stress for me that's acceptable for both of us. It alleviates my stress to throw things. It does not alleviate anybody else's stress. So that's not a good answer. But I still need to have a behavior that I can replace the bad behavior with, I mean the inappropriate behavior, and it still meets my needs. So I need to be taught, Elizabeth, when you feel that red rushing up your eyes and you can't take it anymore, you have an outlet. You have an outlet that's not throwing. Let me teach you how to utilize it. Let me teach you how to recognize it in yourself, and let me teach you how to use a different skill appropriately. So what we talk about when we are making a behavior is first we identify what's going to be taught, and then we make it measurable. So we describe the factors around when this is going to happen. And this goal for me to do it, and this is the part I've been yakking about for 10 minutes, and I'm going to say it one more time, is the last bullet: functionally equivalent replacement behavior. Not replacement behavior, stay in your seat. Functionally equivalent replacement behavior. What gives me the same relief that throwing or bouncing or yelling or touching does? You want to flip? I want to compare this because so many of our kids in the juvenile system do have what we call behavior challenges. The top one is the kind of behavior goal I see all the time. It sounds okay. By a certain date, Sam's episodes of saying you can't make me or sliding down in the seat are going to decrease to less than 2 times a month over a 3-year month in the classes Sam hates, as measured by a teacher charting me on a little chart. And then what happens is I get teacher reports and it shows this little chart where, whoop, I was really bad. Whoop, I'm okay. Whoop, I was really bad. I mean, all right, fine. We know that I've got a behavior and we're tracking it. But what are we doing to decrease that? And where's the functional replacement? If you do a functional equivalent replacement behavior, the one below, what we're looking at is we're saying, what are we going to do? We're going to teach Sam to present a card. Okay. We're going to say, Sam, when you need to escape, that's what you need. We're going to let you escape because it's too much for you, but you have to escape safely. So present your card, get up and walk down to the counselor's office or whomever we've decided your safe space is, and do it quietly so we don't disrupt others. And then we can measure whether we have effectively taught that skill, because that's what we're really trying to see. Did we teach? So the net outcome is I'm not disrupting anybody. But what we are doing in terms of the goal is saying, I will reflect what I've been taught to get to where we all need to be. This isn't easy. And a lot of staff that I run into don't understand it. And a lot of staff are really frustrated. And to give staff their due, setting COVID aside, okay, which has exacerbated everything. If you're a teacher with 20 to 30 kids, you can get frustrated, you can get short, you don't have the time, et cetera, et cetera. But that's what we're here for. What we're here for is to encourage the people to see it and see it right. And I will tell you, I've been in IEPs where kids have been out of control. And once we figured out what is the underlying, verification, and once we put in place it, staff is like, thank you. I can now have Sam in my classroom. He's doing well. Yeah, he still leaves a lot, but I see that as self-advocacy. I see him being able to control himself. I hope, and our next goal will be that he uses it less often because he can control himself for longer periods through instruction. But I mean, it's going to take steps. So, I mean, these things, you as advocates can definitely assist the school in finding that space for the child you're working with.
One just quick thing here I wanted to mention, and this is a perfect, especially when you're looking at the functional equivalent replacement behavior goal, is a perfect marriage of an accommodation in addition to instruction, right? The accommodation is this pass card. Elizabeth kind of talked about that those are 2 separate things. Instruction, or is that direct service or direct instruction on how do I regulate my behavior? And they're 2 separate things, but they're married here in this goal. And it's so fundamental, especially when we're looking at behavior intervention plans, to think through what does that look like?
And once we have this plan and we've decided that what we're going to teach Sam is to self-regulate by using a behavior card, and we're marrying these in that IEP, we're going to see this goal. And then we're also going to look into the instruction area, and we're going to see how much instruction. So where it says services, related services, kind of at the end of the IEP, there's the, okay, we set all this stuff up. Now here's what you get. Understand that that's a very important time to say, okay, we've worked really hard. We've made some beautiful, strong goals. We think these goals are appropriate, and we believe if they are met, Sam will be able to access his education. Wonderful. And we get down and we've got 6 goals, and we see services, and it's 10 minutes twice a week of direct instruction. We have to ask ourselves, 10 minutes twice a week of direct instruction, is that truly enough? And I think one of the most important things is, again, I'm not faulting schools for not having enough money and not having enough teachers and not having enough time. These are unusual times at best. Notwithstanding that, it's appropriate to say, let's get real, people. We just spent all this time studying this. Is this going to be enough? Now, sometimes you want to say, well, in order to do this, we're going to have to give this kid 6 hours a day. Okay. That might be true, but it's probably not the best approach either, because what else do we want? We want the child to also be working on all the rest of things that are happening in school. These goals and objectives have to be embedded, and the instruction embedded in the various areas. So social emotional regulation can happen in science, social studies, math, arts, English, playground. It can happen anywhere. So people can push in and just have a reminder. There's a lot of ways that this can happen, but you do need to be very careful to ensure that you are getting the appropriate amount. Now, how do you know whether you're getting the appropriate amount or not? Remember when I was talking about progress notes? Okay, we set the goals. Everybody said we think 20 minutes once a week is enough. Okay, let's see. After 2 quarters, so 6 months have gone, or I don't know, 2 semesters have gone by. We look, Johnny's not going to make it. They're not going to meet this goal. If the goal was good, that tells you you need more service. And you need to go back and say, we tried it with 20 minutes. It's not working. We still think the goal is good. We need 30 minutes. We should be doing that before the end of the school year. We don't want to wait a whole school year and then set the same dang objective with more services the next year, because what just happened to Johnny? He's a year behind.
Okay.
You want to do this one?
Yeah. Yeah, of course. So I think we just kind of went through IDEA and we mentioned this briefly, but FAPE and juvenile correction facilities, just because you are in a group home, you are in YRTC, you are in a detention facility, does not mean that your education rights go away or go out the door. They may be limited. They may have different rules. There's Rule 18. We can go into all of that, but it doesn't mean that they completely go out the door. So those IDEA protections apply to students with disabilities in all entities, and they also apply to their parents. So if you, yes, Elizabeth?
I was going to say, I just don't want to miss out. While it is somewhat complex, generally speaking, the school district that the student was last located in has the obligation to continue to provide those services. So if I'm a kid that managed to get myself into DCYC, that doesn't mean my special education stops. And if I was a child in OPS before I went to DCYC, then OPS continues to maintain the obligation to ensure that my IEP is implemented at DCYC. What Lauren said is it might look a little different because DCYC might have a different schedule. DCYC might have different courses at different times, but all those services and accommodations with regard to teaching me reading, improving my math skills, improving my social skills, that instruction needs to be ongoing. I think that's the point that we need to understand. It just doesn't stop. Now, Lauren mentioned Rule 18 schools. There's different ways that schools are accredited. Rule 18 schools might be schools like Boys Town, Kearney. They exist to provide education. So depending on how you get there, that you may be getting education as well as other rehabilitative services. But if you are moved to an entity, let me give you an example. If you're a kid that goes to Whitehall and Lincoln, and you're sent there by the court because you need that type of a structure for other reasons, the education still remains with the district that your child was in when they went to Whitehall. Now that district may contract, Whitehall's in Lincoln for those of you who don't know. So if it's an Omaha area district that is the home district, that district may contract with somebody in Lincoln to provide the special education instruction, supports, and services. But those things keep right on trucking. That's the point of this.
Okay. So there's also, we'll just kind of go over this very quickly. There's also, what if the IEP, we talked about it as a framework, as a contract, right? What if that contract or the IEP is violated, or you think that your child is not receiving those services, or they haven't received an IEP in a detention facility or in YRTC? What can you do? There is dispute resolution here in Nebraska, and it goes through multitudes of steps. We're not going to go through every single angle, but we want you to know that they exist. There is IEP facilitation. It has kind of a trained facilitator who's a neutral party who will try to kind of talk with families or the parties to discuss what are the issues in the IEP. This can also then elevate to a mediation. A trained mediator, as many attorneys may know, has to also take kind of a neutral role. They can't inform the parties about what the law is. One of our concerns sometimes in the mediation process is that sometimes families waive their rights unknowingly because oftentimes they don't go in with an advocate. But this is a process that can exist. A state complaint, anybody can file a state complaint, any advocate, anybody with education rights, any parent, any teacher, anybody can file a state complaint. And this is specifically saying that a particular district has not followed the special education law within that last calendar year, in particular, like either to a student or a group of students. And then there's due process. And due process is essentially the legal, administrative appellate process, which by parents and districts can make decisions with a hearing officer who is a licensed attorney who is contracted by districts or the NDE, by the NDE to actually assess the merits of a case. In this due process facilitation, rules of evidence do not apply, but the record is being made. And so sometimes it is extremely beneficial, not even sometimes, always, to have an attorney at your side, especially if you're an advocate in there. Elizabeth, anything I missed here?
Yeah. No, I think you did you covered it all. The IEP facilitation is generally by an educator. Due process is like a mini trial. You're going to have subpoenas, you're going to have witnesses, you're going to have depositions, you're going to have, this is why Lauren said you probably want a lawyer there if you're doing due process, because families don't understand the law, and it's substantially similar to any other mini trial or any other trial. And then you do have the right to, of course, appeal it to the district court, and the district court has a specific, what do I want to say, what it can and cannot do based on the actions that the school district took to determine whether or not the hearing officer's conclusions are right or wrong. It's kind of a modified de novo review that the district court does, but they're going to be looking for a record that looks like a court record.
Okay. If you are interested in due process complaints in Nebraska, you can go to Rule 55. It's listed out there. I know that's what you want to do on a Thursday evening when, next to a glass of wine. That's totally what Elizabeth and I do on a frequent basis. So here you go. So really, what does this look like for all of you? And I think I've stopped, but you might be able to hear my voice. How can an advocate best serve a child's education needs? Now, we kind of talked about this, like what those red flags are, but consistently poor grades. If you have a child who has consistently poor grades, meeting developmental milestones, lack of interest in school, frequent misbehavior or truancy, all of those are those red flags that we discussed before that may indicate that a child either needs an evaluation, they may need, if they have an IEP, maybe their IEP isn't specific enough. Maybe they don't have a comprehensive behavior intervention plan, or maybe the district is doing everything, and that's good to know too, right? And we need other rehabilitation efforts. If you identify what those unmet needs are, you want to make sure that that is included in a report to the court. What Elizabeth and I do, and I think that this is so fundamental for advocates who are working with juveniles, is to look at all the education records. Frequently, when you receive a juvenile court case, you may get attendance and behavior, but you're not really seeing their entire record from when they started in kindergarten all the way to whatever grade they're in at that point. And I think it is so fundamental to see what every single piece of the puzzle is. Oftentimes, for instance, what we find are either indicators that have gone unnoticed, or this is like a great example. We had a child who was in a neglect case, and this had nothing to do with the school district, but it was an error of the court. The child had been sexually molested by their father. The father was in prison. His rights were about to be terminated, but he still had education rights throughout this entire case. The child was so afraid of her father that, in fact, she was bringing a knife to school to protect herself. And the father was getting information because the court hadn't taken away his rights about where she was and what was happening in the school setting. And so that's an instance of reviewing all those records. We were like, that's really, really bad. That's really, really scary for this child. And it was a protection measure, right? That was something that the school hadn't been notified of and his rights hadn't been taken away. But it was, from a court's perspective, really fundamental to understanding all those rights.
And I want to
give
some other examples about this, because this are the kinds of things people are going to see that you really have to think about when you're bringing it to the attention of the court. You may have a family who believes, and sometimes this is even a cultural thing, there is no such thing as disabilities. I'm not going to let you evaluate my child. But the kids in court, precisely because they haven't gotten the services they need through no, I mean, the school district has said, may we please evaluate, may we please evaluate, and the parent has said no. We see situations where the parent's just a no-show and the parent is so busy. I have literally had, well, asking the court to consider appointing an education surrogate is actually taking away a right of the parent. I have had parents say to the court, please, Your Honor, get an ed surrogate in here. I don't have the capacity to make these decisions. I don't have time. I've got 5 other kids and this one's beyond me. I'm not doing it. I have a job. I'm done. So when you hear those things, instead of saying, well, there are other options, and considering whether the parent truly has the capacity or whether the parent's interest would be served. And I've had judges appoint ed surrogate on a temporary basis just to get the ball rolling. I've had judges order an ed surrogate with the language in the court that this is to also help the parent. So the surrogate is the decision maker, but the surrogate works directly with the parents still come. So it's not a condemnation per se, as much as it is, we need to consider if there is some sort of relief so that a parent that doesn't have the skill set, or whether it's physical, emotional, mental, whatever it is, that we don't leave the kid behind.
One other just quick thing that I want to mention here and why it's so fundamental to understand the records. We've had certain cases, it's not the majority of cases, but certain cases where a child has been misverified, especially sometimes younger children. We've had kids that have come in under an emotional disturbance, and we look at the records and the indicators are they don't interact with their peers appropriately. They flap their arms. They don't know how to verbalize their needs, but they are biting and kicking and throwing desks, right? Well, the kicking, biting, and throwing desks has been evaluated, and therefore the child has been verified with an emotional disturbance. But when we put all of these comprehensive things together, what we then ask for is an evaluation for autism, like from the school. And when they start looking at that more comprehensively, we've had a lot of children then be verified under autism or other verifications. And so I think that that is so fundamental, and why those records are so important. Elizabeth, were you going to mention something real quick?
Nope, I think we have just a few more slides to go, and then we can take questions and answers.
Okay, so some other quick things to just consider. This is just for advocates. If you think that an IEP is inadequate, like we said, and you need a complete rehaul, these are some of those indicators. Have the goals stayed similar or same or similar over several years? Do the progress notes say is the child progressing, but the goals are never actually met? That's why those progress notes are so fundamental. Are the goals SMART, specific, measurable, attainable, realistic, and timely? Is there a BIP? Does it actually involve instruction in replacement behaviors that the child can perform and that the child or the school can accept? And did the school revise the IEP, the BIP, or do we need a new evaluation? Anything I'm missing, Elizabeth, before we jump?
You hit all the fundamentals.
Okay. All right. The power of juvenile court is to ensure a good education plan for the child. And so everybody has a role. The county attorney, is this something, for instance, that needs to be referred in terms of a status fence? Is there an IEP? These are some questions to consider. Probation, will the child be more successful in a different educational environment? What school support will help meet terms of probation and how can it be obtained? Parent and guardians and items, are there red flags? Is child fine being met? Does the child need to be reevaluated? Either public defenders or defense attorneys. Is the child being disciplined for a disability? Has there been a manifestation determination? Can you utilize that in defense of your child? And then either CASAs or the courts, what are their struggles? How can you help in terms of IEP meetings? And then also just being open to understanding what a disability is and that what those legal barriers might be that we can be utilized to rehabilitate a child instead of potentially sending them out of the home. All right, so We've talked about a lot today. We by no means think that you should be experts in this, but we hope that you have a little more knowledge and are able to advocate for the youths that you work with. We have about 5 minutes for questions. If you want to unmute yourself and ask those questions, now is your time.
Or if you're shy, you can put it in the chat. Everybody's a genius, Lauren.
Oh, wow, I'm glad.
You know, this is the down part of Zoom. We can see names, but we don't really know you. So we can call you, oh, there's somebody. I see Lisa Utterback and I know her. So as a good teacher, I'm going to call on her. Lisa.
Yes. How are you? This was fabulous. Thank you so much. I'm not obviously an expert in all of the rules and regulations of special education, but that's why we have Kara Saldanero here on the call, as well as someone else from Student and Community Services. So shoot, I'll try to do the best I can. You're the experts today. I sincerely mean that.
Well, thank you. And Kara, you can tell us if we got off course anywhere. So if you're on here.
I do see some questions in the chat. I'm not quite sure I understand it. Three-legged stools, student, home supports, and educators. See so often the recriminations of the other that makes anyone's goals less likely or possible. Adding legal only attention, how do we help? All right, so I'm going to talk about that a little bit from the perspective of the Education Rights Council. And I am going to look at Kara and Lisa to the extent that we do work a lot with OPS. And it goes sort of like this. Yes, sometimes we do see families that are like this. And by the way, the school district is like this too. They're both mad as heck, right? Everybody's a wet hen. And it's because they've been gone round and round 5 times. One of the things that we try to do initially is play that role of facilitation for the IEP. So while we understand that as lawyers, we have the capacity to take multiple instances, not just with Omaha Public Schools, through a due process system, we understand that the most important thing is the kid. And if we can solve this problem by going directly with the school, looking at the family, looking at what is there, advocating for the things that we know are right, and only looking at, I'll call it litigation, as the resort when truly school districts, and OPS is not one of these school districts, basically says, yeah, make me. Well, then we have the ability to say, okay, I'm happy to make you, right? And we do. But our goal really here is to be the informed voice because it's legally, it's embedded in a legal structure. It often takes a lawyer to understand it. And most lawyers that we know are not familiar with this area. So they need to have the issue recognition that exists. And then we serve as a sounding board for them so that they can serve their clients well. Our goal is really to be that bridge to get that kid quote, rehabilitated and out of the system as soon as possible if we can't keep them from getting in the system. And we do it by being vigorous. I don't think I'm a lay down. Kara's been in a lot of meetings with me. I don't think she's going to say I lay down and die. But I'm also not the person that's being a mean, nasty, aggressive legal ogre, because that's not my role. I think it's unprofessional and inappropriate.
I think also it's just really crucial to understand that ERC exists like for this, talking about building of advocates, right? An alliance of advocates. We can't do this all together. We all collectively believe that every child should be entitled to not just an adequate education, but a truly robust education. And I think that we all believe that. And so we know that the educators, that school districts are, you know, especially right now with COVID, dealing with so much. And so as Elizabeth said, we really try to help navigate that system for families and also for the court systems and for attorneys, because I think so frequently we receive a child is referred to the juvenile court system, and as a former public defender, we don't know what to do with the education needs and probably make some poor choices because we aren't educated in that way as well about their disabilities, about what they can be verified for, and choose to send them out of state or out of home when really those services can be provided in a legal construct. And so
when
that's
you're saying we, Lauren, you mean the system as a whole?
Yes, the system as a whole.
Council tries to stop that.
Yes, sorry, we as a whole, as a system. So I think that it's really important to understand that together there's obviously no silver bullet, but together we can do what's best for kids.
And unfortunately, we find that there's massive need for education across the whole board. Mm-hmm. So it's school staff don't necessarily know. Sometimes school admin, especially in smaller school districts, they don't know. The attorneys that are representing them don't know. The judges don't know. The families don't know. Nobody knows. And it's not like we're saying, gee, wouldn't it be pie in the sky great if we could get this happen? This is the law. All we're doing is saying, hey guys, let's follow the law. Sounds like a good plan, right?
So one quick thing, I see it's 11. I want to be respectful of all of your time. If you have any questions or if you want to learn more about ERC, please feel free to see our website or give us a call. You can also email Elizabeth and I. I'll put that into the chat here at where to email us. We do trainings like this for entities across the state. We can do more specified trainings for you as well. And please feel free to reach out to us if you were saying, hey, we'd really like an advocacy group to come in and train our staff. We would be more than happy to do that because together we can serve kids best. So thank you so much, and we appreciate your time.
Thank you for everyone for attending. This was absolutely wonderful. Thanks, Lauren. Thanks, Elizabeth. This was recorded. The recording will be available on the Douglas County website probably by next week, along with all of our other trainings that we've had. They're all on there under the Juvenile Justice Reform tab. So thank you, everyone, and enjoy the rest of your day.
Thank you.
Thank you.
Bye, Lauren, Elizabeth.